Hello everyone and welcome to Byjus IAS exam prep and welcome to another video in knowledge series. Now in this video we will be discussing about Article 20. So what does Article 20 contain? Article 20 of our Indian Constitution provides for protection in respect of conviction for certain offences. Now it has three elements to it. No ex-post-facto law, no double jeopardy, and no self-incrimination. So what are the provisions and what do these terms, these phrases mean is going to be our content for discussion today. First up is Article 20, Clause 1, which talks about no ex-post-facto law. Firstly, what exactly is an ex-post-facto law? So ex-post-facto law, which is not allowed, is basically a law that retroactively makes criminal conduct that was not criminal when performed, increases the punishment for crimes already committed, or changes the rules of procedure in force at the time an alleged crime was committed in a way substantially disadvantageous to the accused. This is the meaning of ex-post-facto law. This is highly inequitable, highly unjust as a matter of fact, because a punishment for an act which somebody was free to do till say yesterday is totally wrong. Let's take an example. Let's say you are somebody who loves wearing red colored pants. Now it's your choice. In the words of legendary actress Neha Dhupia, you have free choice to wear whatever you want. So let's say you are a Ranveer Singh fan and you love wearing red colored pants and trousers, and you have been wearing it for the past 10-15 odd years. Suddenly the parliament passes a bill from tomorrow onwards, or passes a bill today, saying that wearing of red colored trousers is banned, and anybody found wearing red trousers will be sent to jail for 10 years. Now, the parliament also says that this law comes into effect from 1995, from say 20 years back. There is a problem here. Till today, it was not banned, it was not illegal to wear a red colored trousers. But the law has been passed in such a fashion that it is being made applicable from backdate, retrospective application, ex-post-facto application, making an act which was legal so far now a punishable offense. This means the police will come to your house, will find out all those photographs that you uploaded wearing these red trousers on social media and will arrest you and punish you. This becomes a problem. That is why the idea with respect to ex-post-facto law is to criminalize actions that were legal when committed. Number one. Number two, it also can aggravate a crime by bringing it in a more severe category. Let's say jumping a signal. If you break the traffic signal, you could be fined with say 500 rupees. Now if a law is passed to state that breaking a traffic signal, jumping a signal will impose a penalty of life imprisonment, and this will be applicable from 2015. Now the police will catch hold of all those people who did break the signal earlier and now will take them and put them behind bars for life. This means we are aggravating a crime by bringing it in a more severe category. And thirdly, when you change or increase the punishment for a crime. This again can be seen through various examples. When you make a law and try to increase the punishment by saying that a law which was earlier punishable with a maximum sentence of say 2 years, now you say that under this law, if you commit an offense, you will be punished with 10 years of imprisonment. And this is applicable from 2020 or 2018 or 2010. So this is what is called ex-post-facto law. And that is why I said this is highly inequitable and extremely unjust. So what does clause 1 of Article 20 say? The clause 1 says that there will not be any ex post facto law, meaning laws will not be applicable from backdate. No person shall be convicted of any offence except for a violation of law in force at the time of the commission of the act, charged as an offence. Now let me clarify something here. This word offence is not defined in the Constitution. Though if you want to know the meaning of this word offence, it is defined in the General Clauses Act 1897. Offence simply means any act or omission made punishable by law for the time being. So what kind of offence is something that the courts have interpreted? First things first, you will not be punished for any offence except for violating a law in force at the time you committed the crime. Secondly, nor will you be subjected to a penalty which is greater than that which might have been inflicted under the law in force at the time of the commitment or commission of the offence. As I said, if say 5 years back, it was not banned, it was not punishable, it was not an offence to wear red colored trousers. So the law cannot be made in such a fashion that it is made applicable from backdate. Even if it is, you will not be punished. So this is the idea. Now, when it comes to ex post facto law, some things that you need to understand is that the immunity given under ex post facto law, this immunity is actually limited. This is limited to punishment by courts for criminal offences only. So even though this word offence is not defined here, Supreme Court has interpreted that only criminal laws or offences which require criminal punishments, jail sentences, etc., they will not be applied from backdate. This means this is limited to only, as I said, criminal cases, criminal liability, which means that civil liability can be created from a backdate. If a tax is imposed, the law can be made in such a fashion that the tax can be imposed from a previous date. So let's say the government says we have increased the tax slab to now 50%. Everybody will have to pay 50% income tax, and this is applicable from 2018. Now this is allowed. A civil liability, a tax liability can be imposed from backdate. However, Supreme Court has also clarified on this that nature of activity and the harm it causes to the community is also going to be a very important reason to justify retrospective application of laws. So sometimes laws can be applied from backdate if they cause harm to the public interest at large. But largely, no ex post facto law is limited to criminal cases wherein you will not be punished with a greater sentence than that was at the time you committed a crime. As I said, the idea is to ensure that the people are protected from the arbitrary behavior of the government to avoid misuse of power by the state. And one more thing to add in ex post facto law is this very important fact that when it comes to ex post facto law, the punishment cannot be harsh from backdate. But if the law provides for lenient punishment or maybe reduces the sentence, reduces the punishment, then that can be made applicable from backdate. So a more strict punishment can't be applied from backdate. A lenient punishment, relief, can be applied from backdate. This is no ex post facto law, clause 1 of Article 20. Next is Article 20, clause 2, which talks about no double jeopardy. So what does this mean? This is basically a concept from a Latin phrase nemo debet bis vexere. It simply means a man must not be put twice in peril for the same offence. The idea is that, the state with all its resources should not be allowed to make repeated attempts after attempts to convict an individual for an alleged offence, thereby subjecting that individual to embarrassment, expense and ordeal, and compelling that individual to live in a continuing state of fear, anxiety and insecurity, thereby enhancing the possibility of proving the guilt. This is the idea of no double jeopardy, and this is a concept which is available internationally. In fact, you can find this available in countries like UK, countries like USA. In USA, you have the 5th Amendment, which talks about no double jeopardy, meaning you will not be punished for the same offence more than once. This is what is meant by double jeopardy. Now, there are some clarifications that are required here. First up, the very important clarification is that this is not something unique which happened just recently. No double jeopardy was already present in India as a legal right, as a statutory right. Under CRPC, and when I say CRPC, not the new one, the old one, CRPC 1898, the Code of Criminal Procedure, the older one, also had a provision under one section 403 which talked about the exact same thing, that nobody will be punished more than once for the same offence. So what was originally a legal right is now a constitutional right, number one. Number two, this is limited to only judicial proceedings. So judiciary will not punish you. However, let us say you get very bad marks in your examination and you show the report card to your mother. Your mother firstly slaps you, beats you. In the evening, your father returns, he beats you again for the same report card. Maybe others also beat you, the teacher also beat you for the same report card and same poor performance. You are being punished for the same offence over and over again. This is allowed. You can't go to court and claim Article 20 Clause 2 against those aspects. Or a more rational example. Let's say while your elections were being conducted, your behavior was found to be biased. You were somebody who were performing the tasks of conducting election and your behavior was found to be biased. Election Commission made a negative remark against you in your appraisal report, in your track record. This has now been kept in your service file. Now when the next time the promotions are due for you, your senior officials can look into this negative report and say, oh, this person's behavior is biased. We can't trust him with more power. And they deny you promotion. You are punished for that behavior of yours. After a few years, for that same negative behavior of yours, you can again be punished with denial of promotions. So when it comes to administrative proceedings, etc., you do not have the claim of double jeopardy. It is only something that can be claimed in judicial proceedings. That's number two. And also to clarify here, understand that at a point of time when you commit a crime, there can be various charges levied against you and you can be punished for separate charges separately, even though you have committed the same kind of crime. Just to give an example, let's say you have conspired to commit a crime. There is a conspiracy by you to commit a crime and then you actually committed a crime. These are two different activities. Conspiracy is a different offence. Committing the actual crime is a different offence. You can be punished for two different offences. That's important. To further take this example, let's say a car theft takes place. Now, if you have been punished for stealing a car theft, this means you can obviously be punished in future for another car theft. You can also be punished in future if you steal the same car again. Or you can be punished with additional crime. Let's say you stole the car and also hit somebody on the way that you stole the car. Or you remove the driver from the driver's seat and then stole the car. So additional charges can be levied against you and you can be punished for other kind of offences, but not the same offence twice. And what is very important and different in India than in some other countries like USA and UK is this fact that in USA and UK, both prosecution and punishments are covered. But in India, if you are merely prosecuted and you have not been punished, prosecution without conviction does not give you the protection of Article 20 Clause 2, meaning that if you were acquitted by the court with respect to some crime that was alleged to have been committed by you, the police can again file a case, the same charge can be levied with new evidence against you. You will not be punished for the offence more than once. Till the time you have not been punished, the police can try and file a case against you under the same offence. Secondly, it also does not cover appeals. Let's say a lower court has acquitted you. Then the government, the other people reserve the right to file an appeal against the judgment, which will not be covered under double jeopardy. Now, a very unique issue and a question is normally asked with respect to double jeopardy, and that somehow stems from some movies that showcase this provision. Now, there was a movie, I'm not sure how popular the movie was, but this movie was Luck, starring Mithun Chakravarti, Danny Denzongpa, Imran Khan, Shruti Hassan, etc. In this movie, there was this actor Ravi Kishan who played a role. What they show in the movie is that Ravi Kishan has been given capital punishment, death sentence, and while he is hanged, the rope breaks and he falls down, and then because of the criminal justice system in the country, that's the background voice, the person has to be acquitted. No, that is not how it happens. We have clear-cut provisions under CRPC. If you refer to the Code of Criminal Procedure, that is, I think, section 354, subsection 5 of it. It very clearly says that when a person is sentenced to death, the sentence shall direct that he be hanged by the neck till he is dead. So, until and unless the execution of the sentence is not complete, the person will be hanged. So, if the rope breaks, we'll have to find a new date to hang you. It does not mean that luck favors you and you have to be acquitted. That is very silly. And it is not something new. In fact, even in the original CRPC that was of 1898, there was one section, section 368 if I'm not wrong, which had the similar provision that somebody who has been punished with death sentence is going to be hanged by the neck till he is dead. So don't take your legal cues from the movies and cinema is all I am suggesting. Okay. So this was no double jeopardy. And lastly, we have no self-incrimination. Again, something that is there in other countries also. You can see this in USA as well in their 5th Amendment. What is no self-incrimination? It's very simple. No person shall be accused, accused of any offense shall be compelled. The compulsion here can be, say, a mental compulsion or a physical compulsion. So, no person accused of any offense shall be compelled to be a witness against himself or herself. So, in this situation, you can't be compelled to be a witness against yourself, meaning 3 things. Number 1, the person who is accused is always treated as innocent till you are proven guilty. So there is always this presumption that you are innocent. Though there are some laws, if you break those laws, there is presumption of guilt. For example, a very popular law where there is presumption of guilt is the PCRA 1955 or the SC/ST Prevention of Atrocities Act. Those are exceptional circumstances. Normally, under normal laws, you will always be presumed to be innocent till proven otherwise. First thing. Secondly, it is for the prosecution to establish the guilt. It is of no concern to you. The other party should be given the task, and it is their responsibility to establish whether you actually committed the offense or not. And number 3, very important is this fact that the accused need not make any statement against his or her will. That is why you see in these movies, they make the statement, right to remain silent. You have a right to remain silent, and whatever you say can and will be used against you, etc. So this Article 20 Clause 3 is our right to remain silent. So you have a right to remain silent. Now this compulsion is a testimonial compulsion, meaning you will not be asked into being a witness against yourself. However, Supreme Court in the Kadi Kalu case 1961 has clarified that what do you mean by testimony? If you are being forced into accepting a mistake, that will not be allowed, right? This is basically done to ensure that there is no use of force, because if this happens, there is always this apprehension that compulsory examination of an accused, if it were to be permitted, then there is always this possibility of use of force, torture sometimes, to force the accused into accepting something. A very good example is this Tamil movie Visaranai. This movie, I think it was an Oscar entry for India from 2018, I believe. This movie, at least the first half, showcases beautifully how sometimes police agencies force people into accepting a crime which they may not have committed. Visaranai. Anyway, so the point here is this idea that force and torture should not be used against individuals, forcing them, compelling them to accept, say, a crime which they may or may not have committed. So if you want to willingly accept your mistake, say plea bargaining, that's up to you, it's your choice. Nobody is stopping you from that. But the police will not force you. So what you see that happens, the police very nicely and decently asks you in the lockup with special treatment, that's all not allowed. Those special treatments are not allowed. The idea, as I said, is always to ensure the maintenance of human privacy. Also observance of civil standards in enforcement of criminal justice. Now, one thing which is very important is in this Kadi Kalu case, Supreme Court said that this kind of compulsion or this kind of complete immunity of self-incrimination does not extend to certain areas, like the police officials can force you into compulsory production of material objects, let's say your mobile phone, your laptop, right? They can ask you for a mobile phone password, which you may not want to give. It's better to die than to give a mobile phone password. That's a secondary matter. But they may compel you into giving your laptop, your mobile phone password, your mobile phone, your thumb impression, your specimen signature, your blood sample, urine sample, exhibition of body, footprint, fingerprint, etc. These things are not covered under self-incrimination. Obviously, the law enforcement agencies also have to be armed appropriately to ensure justice. So these things are not given that protection. And lastly, this only extends to criminal proceedings and not civil proceedings. Though in countries like USA and UK, this extends to both civil and criminal proceedings. Whereas in India, this immunity extends only to criminal proceedings. And lastly, one more small addition to 20 Clause 3 is this Selvi case, Selvi versus State of Karnataka in the year 2010. Now you must have seen all these scientific techniques, things like narco-analysis, which is also called truth serum. It is simply injecting the human body with some chemicals. Just like when you drink, you start blurting out the truth. You stop or you lose your control over your senses. The same logic applies. Some drugs are injected and then the person may lose self-control and possibly can say something which can be held against him or her. So things like, narco-analysis, things like this P300 test, or the BEAP, that you have brain electrical activation profile, things like brain mapping, or the very famous lie detector test, polygraph tests. These tests can't be conducted against any person without their consent. So consent is required to conduct any kind of scientific techniques to be imposed on people, and that is why these tests also trigger immunity of Article 20 Clause 3. You can't conduct these tests without the permission of the accused. So this is no self-incrimination. So these are the three provisions as far as Article 20 is concerned. Clause 1 talks about no ex post facto law. Clause 2 talks about no double jeopardy. And clause 3 talks about no self-incrimination. So this is all as far as Article 20 is concerned. Let's take up some questions that you have from Article 20. Questions, please. Surbhi, retrospective backdate. So it means from backdate. As I said, let's say there is a law, there is no law as such which punishes anyone from eating chicken. But if a law is passed that eating chicken is now an offense, anybody found eating chicken or anybody who has been eating chicken will be hanged till death. And this law comes into force from 2015. Backdate, retrospectively. So anyone who had been eating chicken from 2015 will be hanged till death. This is called retrospective effect. Being rhapsodic. See, when it comes to such kind of laws where legal age has been increased or decreased, or not decreased, increased only, then previous marriages will not be declared null and void, because these laws will have provisions which say that this law is applicable from this date. Otherwise makes no sense. You can't make laws like this and make all these previous marriages illegal, null and void. This also violates the dignity of individuals. So no, that law will be applicable from that date onwards. Ashutosh, sir, isn't in Mohammad Zubair's case there is violation of double jeopardy while same relief is given to Nupur Sharma? No, there is no violation of double jeopardy. You have to also look into this idea that cases can be filed by multiple people at multiple places. The same was done for Nupur Sharma also. I mean, the relief given to her yesterday only came after very unique comments made by Supreme Court a few days back. And when it comes to Mohammad Zubair's case, there has been a history of tweets from this person on various kind of issues and comments on hurting sentiments of certain community. So again, it depends on what kind of complaints have been filed. It depends on what is the evidence that people are using in various court cases. And largely, eventually Supreme Court has this power, the power to club all the cases and transfer the cases to one high court, or from one high court to the other high court, or from one court to the other, or even to itself. This power is already available with Supreme Court, and this can be done by the Supreme Court on its own, or at the request of the parties involved, or if the Attorney General, the Solicitor General, or the Advocate General so requests. Surbhi, why was it needed to be put in fundamental right? See, a legal right has protection, but a fundamental right is protected by the fundamental law of the land, that is the Indian Constitution. So to ensure that these are extremely important, to ensure the dignity of individuals, to prevent the state from having arbitrary powers, we have placed these under Article 20. Why? Because for the protection of the fundamental rights, you can directly approach the Supreme Court. Though Supreme Court in 1987 has already clarified in the P.N. Kumar case that please approach the high courts first, but you can approach the Supreme Courts. So it is very, very important to understand the fundamental rights in the context of Article 32, that is right to constitutional remedies, which Ambedkar has called the soul, the very heart of the Constitution. It protects these rights which the utmost, the highest court of this country, the apex court of this country, protects the fundamental rights. Shikhar, not at all. Article 20 clause 3 is not an absolute right. As I just said, there are so many limitations on it that you can be forced into giving blood sample, you can be forced into giving your urine sample, you can be forced into exhibiting your body, your handwriting sample, your signature specimen, your footprint, your thumbprint, your fingerprint. So it is not absolute. In fact, as a general rule, our fundamental rights are not in general absolute. Don't compare the rights in India, the fundamental rights in India, to that of USA. In India, our fundamental rights are always qualified in nature, meaning reasonable restrictions can be imposed on our fundamental rights, but the restrictions should come through a law. BAP, brain narcoanalysis are violations of Article 21 right to privacy as well. Yes, definitely. They are also violation of right to privacy if they are performed without the consent of the accused. I think this has been shown in a movie called Talwar. If you see this movie called Talwar starring this late actor Irfan Khan, it is based on a real life story of a murder which happened in Delhi and based on his book. So in that movie, one section of CBI, which initially is conducting the investigations, they use narcoanalysis without the consent of the accused, which is then not accepted by the court. Kanupriya, narcoanalysis cannot be used as a first evidence in the court. It can be supplemented and can also help the police in conducting or channelizing their direction of investigations. It can't be used as a primary evidence in the court. Mangaldeep, self-incrimination, is it defined in our constitution? Not really. See, that is the whole point here, that in our constitution, not a lot of things are defined. Because if we start defining these terms, it could result in a big challenge. Already, our constitution is the largest amongst all the countries with over 1.2 lakh words. We can't increase it further. So, I mean, we can, but again, there is no point in defining these terms. Definitions mostly come from either the General Clauses Act or Supreme Court can interpret these definitions time and again if there is any dispute with respect to any word. No ex-post-facto law is not applicable in civil cases. Kanupriya, exactly, it is not applicable with respect to civil cases. Civil laws can be applied from backdate. Can be applied. It depends on whether the government wants to apply those laws from backdate or not. For example, a tax liability can be applied from backdate. Okay, again, I think the same point which would be that what is the impact if self-incrimination extends to civil cases also? Again, the impact is going to be, it is going to be extremely difficult to prove civil crimes, and civil crimes do not have the same sense of punishment as the criminal cases, and hence we have this bifurcation, this distinction, that let it be limited only to criminal proceedings, so as not to harass the person, so as to maintain the basic decency while we are questioning any accused. That's how the courts see it. So I believe that is all as far as the questions with respect to Article 20 are concerned. Okay, that is all as far as this video is concerned. We'll meet in the next video. Till then, Jai Hind.